Hello, friends. I wanted to let everyone know that we are going to get started in just a few minutes. So if you all would find your seats, we'll be ready to get the show moving here in just a couple of minutes. Good morning, my friends. Thank you so much for driving in this morning and spending a little bit of time reconnecting with some old friends in the room. It's really nice to have this crowd together with us today. So fun to be in this gorgeous building and really nice to see all your faces. It is moments like this that kind of feel a little bit like a reunion and fun to watch all of you reconnect with each other. Today, we are so excited to bring many brilliant people together to share their knowledge and spark discussion about one of the biggest disruptors to the legal landscape in recent years, artificial intelligence. But before we dive in, I would like to draw your attention to one of your handouts. You do have a two-sided document. One side is today's program evaluation, and the other is your CLE form. So to be able to receive those CLE credit hours, You do need to complete that and turn that in at the end of the day at those 2 registration desks right over here. So please don't forget to do that. We'll give you an activity code later today and you can turn that in. We have lots of great speakers lined up today who have put together some really interesting resources and handouts, and those will all be shared via email here in a few days, along with a link to the recording of this symposium. And with that, it is my pleasure to welcome to the stage Jonathan Hollingsworth, our board president and fellows class of 2010, to say a few words.
Thank you, LB. I have to agree that this room is filled with some very smart people, many of whom I've worked with over the last 43 years of my life in the profession. And when you get together with great people, great conversations happen. We can all learn a lot from one another today. So pay attention. The smart people will be following me. So thank you all for joining us today for the OSBF's AI and the Law Symposium. On behalf of the Board of Trustees and the fellows and the staff, I want to thank you for being here. The rise of artificial intelligence is affecting many professions, and we are not exempt from that. We're practicing law at a truly fascinating time. And for people like me who started 43 years ago, I thought getting a computer was a big deal. Imagine what life is like today. AI is affecting the law in almost every aspect of our lives, but with respect to the change that's happening, it's bringing up a lot of great questions that we hope to have answered today, or at least get us started along the road of trying to identify what are the ethically and safe ways to use AI. But before I dive into these meaningful conversations, I'd like to take a minute to acknowledge the Foundation's 75th anniversary. For those of you who don't know that, that's a big deal for us. So I think we should celebrate being 75 years old. Now, the symposium is presented by the Ohio State Bar Foundation, a nonprofit, but we are the largest bar foundation in the United States, and we take great pride in that. The OSBF works to help build a strong legal system through grant making, honors the accomplishments and dedication of lawyers who give back to their communities through our awards program, and we unite attorneys around the state of Ohio through our Fellows program. My notes are a little, there they are. Now, over the last 75 years, we've awarded more than $19 million in grants to organizations across Ohio. And 2025 was an extraordinary year because in 2025, we made our largest grant allocation to date. 2026 is a milestone year in the foundation with a wonderful class of fellows from 25 as well as 26 who are promoting legal excellence in Ohio and who are deeply committed to serving their communities. If you are a fellow, the class of 2025, 2026, or even 2010, please stand so that we might recognize your work. Now, the 2025 Fellows class came together to select today's critical event topic of AI and the law. I offer a special thanks to them, as well as to our sponsors, Fisher Phillips, Boston McKinney Law Offices, Cabbage, Familio, and Durkin, Yokin Law, my good friend Ben France, and Mills James. You too can support the OSBF and get involved by visiting osbf.org, where you can donate, become a fellow, nominate a person or organization for an award, or apply for a grant. I believe this year might even be better than 2025, so if you've got a good program, please don't hesitate to submit your grant. Thank you for your support and for joining us today. I look forward to learning something new alongside you all. Please join me in welcoming Lori Beth back to the stage.
All right. Well, this is an exciting moment where we're going to start to kick off this conversation. I want to thank again this year's Fellows class for selecting this as a topic. It is a moment that feels more relevant than ever. Over 75 years, we have seen a lot as an organization and have watched the law evolve. We're standing on the precipice of another great change to the legal landscape and must ask, how do we integrate AI in the best way possible to serve the people? We have curated 2 impressive panels of topic experts today, preceded by keynote speaker Jeremy Kahn. He is the AI editor of Fortune magazine and author of Mastering AI, a survival guide to our superpowered future. There's a lot to learn, and we hope that you'll enjoy the full program today, including our closing segment where an AI bot will take the reins in a deposition. Thank you for attending and making this possible. We'll have time for a couple of questions after each presentation. And so at this point, I think we are going to welcome to our screen our keynote speaker, Jeremy Kahn, author, editor, and AI expert, live from London, England.
Thank you, Lisa, for the kind introduction. It's a pleasure to be here with you today, coming to you from Oxford, England, where I live. As mentioned, I'm Jeremy Kahn. I am the AI editor at Fortune, the business publication. That means I lead a team responsible for covering the leading AI companies and also covering AI's impact on business. I write a newsletter for Fortune called Eye on AI that covers the latest developments in the field. It comes out twice a week and it's free to sign up. So if you aren't already subscribers, I hope you will consider subscribing. I'm also the author of Mastering AI, a survival guide to our superpowered future, published by Simon & Schuster. You can pick up a copy wherever you buy your books. I have been asked to give an overview of how we arrived at this moment in AI, what the latest is in terms of the technology, and what impacts we are seeing on business and the economy, society, and democracy, before giving some high-level thoughts about the specific impacts on law and the legal profession that may preview a bit of what you are going to hear later in the day from other speakers. It's always good to start with a joke. So, have you heard the one about the robot lawyer? It walks into a law firm and says, I can review 10,000 documents in an hour. I never sleep, and I don't bill for lunch. The partners look at each other and say, yes, but can you play golf? Okay, that joke was actually suggested to me by Anthropic's AI model Claude, so thanks to Claude for that. I guess AI is good for at least something.
So actually, that's not the real Jeremy Kahn. I am the real Jeremy Kahn. And thank goodness I don't sound like that in real life. What you just watched was an AI avatar of me, what some would call a deep fake, created with software from a British startup called Synthesia. It took about 5 minutes of video and recorded audio on my laptop to create that avatar, and doing so required no technical knowledge on my part whatsoever. These deepfakes no longer have some of the telltale signs that were noticeable just a few years ago, like a lack of blinking or unrealistic hands or visual blurring around the ears and jawline. The voice here was still a little bit robotic. I probably could have done some things to improve that, but straight out of the box, still a little bit robotic. But it's pretty close to the point where you genuinely cannot tell. And the ability to deepfake pretty much anything is one of the issues around AI that will pose real challenges for courts and judges going forward. It's one of the issues I'm going to explore in my talk today, but we'll get to that in a second. Again, I want to thank the Ohio State Bar Foundation for having me here. It's a real pleasure to appear before an Ohio crowd. I'm sorry I couldn't be there live and in person, but I grew up in Cleveland, so I think very fondly of Ohio. We've got a lot of great lawyers in Ohio. Before we get into the heart of this, I always start my talks with a little bit of history that is particularly relevant to how we arrive at this AI moment. The history I want to convey is really about two figures who were early pioneers in AI, one of whom you probably know, and the other is probably less familiar to you. Those two figures are Alan Turing and Joseph Weizenbaum. Alan Turing was, of course, the brilliant British mathematician most famous for helping crack the Nazi Enigma code during the Second World War. But Turing also pioneered some of our first computers and was instrumental in thinking about the idea of machines that could, quote unquote, think. In a 1950 essay called Computing Machinery and Intelligence, Turing proposed what he called the imitation game. Yes, you might know that from the title of the Benedict Cumberbatch movie, which was about Turing's life, but that movie actually doesn't cover this period of Turing's career. Turing invented this thing called the imitation game, which today is much better known as the Turing test, to deal with the fact that we didn't, and actually we still don't, have a very good definition of what intelligence is. So instead of trying to define it, Turing proposed a Potter Stewart-esque, I know it when I see it kind of test. A machine would be considered intelligent, Turing said, if it could hold a conversation, a general conversation about any topic with a person and another person, seeing only the message traffic passing between this person and the machine, could not determine which of the messages had been written by the computer and which by the human. The Turing test has actually cast a very long shadow over the entire field of AI. Passing the Turing test became the goal of the field for decades. Arguably, we blew past the Turing test in November 2022 when OpenAI released ChatGPT. Today, it is very difficult to tell AI-generated text from human writing. You know, there are certain tells, people talk about em dashes or overuses of certain words and phrasing, but in many ways, it's really hard to tell AI-generated text from human writing. And a lot of people think the test is not actually that relevant anymore. It turned out it did not settle the argument about whether AI is truly intelligent. But the Turing test had what I would argue is a really troubling legacy on the field for four reasons that we should keep in mind as we think about AI's impact on society and AI's impact on the law. First, it elided the need for a definition of intelligence, which I think would still be a pretty useful thing to have. Second, it enshrined the idea of deception right at the heart of the AI field. The purpose of the technology in the Turing test was to fool people. That has a direct relevance for how we think about the uses of AI today, whether that's deepfakes or other AI-generated content. Third, the Turing test drew no distinction between the imitation of human dialogue and the dialogue itself. It conflates outcomes with process. And I would argue that when we talk about intelligence, we care a great deal about process, not just about outcomes. Finally, the Turing test set up a contest of wits between man and machine. The machine's task was to get the better of a person, to equal human output, to fool that other person who was watching the dialogue, not to assist a person or augment them in some way. The economist Eric Brynjolfsson who is at Stanford, he refers to this as the Turing trap. And it has had some serious and is having some serious economic consequences. Although there is much evidence that in many cases, it is the combination of people assisted by AI technology. This is sometimes called a centaur solution, where you combine AI, the best of AI with the best of what humans can do. There's a lot of evidence that these kinds of centaur solutions perform better than either AI or people can alone. And yet companies tend to see AI as a direct replacement for human labor rather than a tool for augmentation. And this has led, some companies to decide that they would rather, start cutting jobs as they can replace people with AI technology. I think lots of people in the field always benchmark technology against human level performance, there's very little benchmarking actually of what AI can do when it assists a person. How much better is a person when assisted by AI technology, as opposed to simply always putting the AI in a head-to-head contest against human practitioners. So I think that's one of the sort of bad legacies of the Turing test. Now, some people think we passed the Turing test for the first time, as I said, when ChatGPT debuted in 2022. But actually, the first AI system that came very close to convincing a lot of people that we had passed the Turing test arrived way back in 1969. That technology was a chatbot as well, one of the very first chatbots. It was called ELIZA, and it was programmed by an MIT computer scientist named Joseph Weizenbaum. ELIZA was designed to act like a psychotherapist. It would parrot back what someone typed to it and throw in some vague phrases like, "Oh, that's interesting, tell me more," or "Why do you think that is?" And despite the fact this wasn't very sophisticated programming, it was nowhere near as sophisticated as the AI models we have now. It didn't have any real understanding of language. ELIZA utterly convinced a lot of people. There were a lot of people who did not believe that they were talking to a computer and not to an actual psychotherapist. Even some computer scientists who knew better and knew exactly what ELIZA was found themselves drawn to confessing intimate details of their lives to the chatbot. Our tendency to anthropomorphize chatbots and assume them to be more intelligent and human-like than they are actually is today still called the ELIZA effect. Weizenbaum, this should have been some great triumph for Weizenbaum. After all, he had created this chatbot that was so convincing. But Weizenbaum was actually appalled by humans' reactions to ELIZA. He was very disturbed by the fact that we were so gullible as to think that this very simple program was intelligent. And as he began sort of unpacking why he was so disturbed by what he had created and by people's reaction to ELIZA, he came to turn against the entire field of AI, really. In sort of turning against the field, Weizenbaum made a number of very prescient predictions of some of the problems that AI was likely to cause in the future. He worried about three things in particular that I think we should keep in mind today. The first was that AI could become an instrument of totalitarian control. This is something that the historian Yuval Noah Harari has more recently been warning about. And if you've been following the news about Anthropic's fight with the Pentagon, one of the things at issue there was that Anthropic was very concerned that the Pentagon might use commercially obtained data to essentially engage in mass surveillance of US citizens. So I think this is like, one of the things Weizenbaum warned about is very much front and center today. The second is that Weizenbaum said we should stop arguing about AI's place in society from the perspective of only looking at its technical capabilities. What can the technology do? What can it not do? He said that this missed the real debate society needed to have, which was this: assume AI is technically capable of doing everything better than a person, because Weizenbaum, seeing the trajectory of the technology, even back in 1969, was sure that AI would eventually get to this point. But he said we should really ask ourselves, are there certain areas of our lives and our society where we don't want AI to be used? Weizenbaum said that there were. In particular, he did not think AI should be involved in sitting in judgment of another human being in the legal system, especially when the consequences were potentially the loss of liberty or even life. His reason was that every defendant should have the right to have their case heard by another person, someone with lived experience, who knows what it is to be human, because only then can there really be the justice that we seek. Only then can there be the possibility of mercy. Okay, that's getting a bit heavy, so here's another AI joke. This one written by a person, I swear. People worry about AI becoming self-aware. Meanwhile, I can't even get my toaster to understand lightly brown. Okay, that's vaguely amusing. But it does point to where we are with AI technology today. We live in a world that Google CEO Sundar Pichai and AI policy researcher Helen Toner have both called the age of quote unquote jagged intelligence. AI is remarkably capable in some domains and yet fails completely in others, sometimes in tasks that we would view as much simpler than the thing that the AI excels at. We have passed the Turing test, for instance, but we have not yet passed the coffee test proposed by Apple co-founder Steve Wozniak. That test was to say, walk into a random, unfamiliar kitchen and successfully make yourself a cup of coffee. Humans can do this pretty well. AI, and there have been a number of tests of the large language models to see if they can do this. The answer is not yet. And they certainly can't direct a robot to do it in an unfamiliar kitchen. Jan LeCun, who is one of the so-called godfathers of AI, one of the real pioneers of the deep learning techniques that underpin today's large language models, says we don't even have cat intelligence yet, let alone the kind of human-like artificial general intelligence that is the holy grail of the leading AI labs. A recent paper that was co-authored by another one of the godfathers of AI, Yoshua Bengio, evaluated leading AI models against the Cattell-Horn-Carroll theory of human cognitive ability. This divides intelligence into 10 separate areas. They found that today's advanced AI is pretty good at general knowledge, reading and writing, and mathematics. It's so-so at reasoning, and it's terrible actually at most tasks that involve memory of new things that would come up in the conversation with that model. They have very good memory of the things that they've been trained on in their initial training, but they don't really learn on the fly from how you interact with them. That said, AI continues to make rapid progress. And there were several new developments in just the past year that have made these models significantly more powerful. The big change in 2025 was the advent of so-called reasoning models that appear to follow a chain of thought and can try different approaches to solving a problem. Those reasoning models have led to increasingly what are called agentic AI systems. This is software that doesn't just generate content or answer questions, but performs tasks using other software tools. It can break a job into subtasks and tackle them in parallel or in sequence, depending on what the model thinks is best. And these agents follow essentially what's called an agentic loop. The loop consists of 3 steps, first being plan, the second act, and the third reflect. And through that, they can take quite sophisticated actions and work independently on tasks for quite long periods of time. We've seen, for instance, the debut of very sophisticated coding agents that can create entire computer programs just from a description of what that program should do. They can actually test and debug that program as well. We've started to see models that are trained on much more expert inputs from professionals, including experienced lawyers. So one of the big changes in the past year is the augmentation of the training of these models with a lot of input from experienced professionals from across different domains of knowledge work. And yet still there's this jaggedness of AI performance. And I think that jaggedness explains a lot of the rather confusing headlines we've seen recently. On the one hand, we have companies like the payments provider Block slashing its workforce because it says that AI has gotten so good it no longer needs as many human software developers. And you have things like reports about AI's model Claude in a safety test resorting to blackmail to avoid being shut down. Quite a scary safety test. Although you'll be happy to know that some very recent research that came out in the past few weeks that looked at how these models are used in most actual production environments found that the chance of blackmail actually occurring in most of these real-world settings was very, very low. So we have, on the one hand, we have stories like that. On the other, we have stories like the survey from MIT that got so much attention at the end of last year that said that 95% of AI pilots fail to deliver a return on investment. This jaggedness makes it genuinely difficult for companies to figure out how to use AI effectively. And I think a lot of law firms also are struggling with this issue of exactly where they should deploy AI and what the most effective way to do so is. And I'm sure you're going to be discussing a lot of that more later today. That said, we are starting to see real deployments at scale, and the progress has been particularly rapid in a few areas. One, of course, is coding. At leading AI labs like Anthropic, more than 80% of the software code is now AI generated. Anthropic's model Claude now writes most of the code for the next generation of itself. Other tech companies like Microsoft say that at least 40% of their code is AI written. And many firms, including Amazon, for instance, are mandating that their engineers use AI coding tools. But there can be issues. Amazon's internal coding agent, Kiro, has taken erroneous actions that have reportedly been implicated in major service outages, and the company is having to introduce new verification steps to try to prevent that. Outside of coding, one of the areas where AI has made the most progress is customer service. Salesforce says that 81% of customer calls are now handled by AI, and they are able to autonomously resolve 55% of those cases. The rest are escalated to a human. Another area where we've seen a lot of progress is simply document processing. The pharmaceutical company Novo Nordisk has taken a clinical trial reporting process that used to take a team of as many as 10 people as long as 12 weeks to complete, and have reduced that entire thing to 10 minutes. So that's quite impactful. Throughout healthcare, AI is making progress. AI is being used for help doctors take notes. It's being used to help code things for insurance purposes and for billing. And it's even negotiating insurance claims, which is a situation where we literally have sort of bot versus bot. You have tools like ChatGPT and specialized software, such as one called Claimable, that are going up against other software from United Healthcare, for instance. They have a system called NH Predict. And you essentially have these systems arguing with one another over whether claims should be paid and how they should be coded. So what's coming next? And I promise I'll get to some specific legal cases in a bit, but just generally what's coming next. The answer is more and more autonomy, for one. Some of you may have heard about OpenClaw, which has gotten a lot of attention recently. This is a kind of agentic AI system. It allows you to have an AI agent take over your computer and run all sorts of tasks for you over long periods of time. It generated a lot of attention when someone decided to create a social network for these AI agents called Moltbook, where some of the agents appeared to talk about wanting to establish encrypted communication channels away from people and plotting to escape human control. It turned out the most provocative of those messages were written by humans masquerading as bots. And the truly scary part of Moltbook was not really about the bots wanting to escape control. It was that the site contained a good deal of malware and so-called prompt injection attacks in which someone plants malicious instructions somewhere for an AI agent to read. And because these agents don't currently distinguish between the user's instructions and other instructions they may encounter, they can be tricked into doing things like exporting your email or bank account information to a bad actor. The world of these agents is genuinely the Wild West right now. We're also going to see much more sophisticated AI-generated video. We're starting to see more in what's called embodied AI. This is the use of AI in systems that take action in the real world. The best example of that is autonomous vehicles, which are coming to more and more cities. For a long time, it was only San Francisco and a few neighborhoods in Phoenix where you could hail a Waymo or an autonomous vehicle from one of the other companies. But more and more cities are going to start to see these robo-taxis very soon. We are starting to see more flexible and intelligent robots in factories and warehouses, including some humanoid robots in these industrial contexts. There's a lot of excitement about humanoid robots coming to the home, that we're all going to have like a personal butler at some point very soon. I think that's actually a little ways off. When you talk to roboticists, there are some real safety issues to solve to have these things in the home. These robots tend to weigh quite a bit. It's a real problem if they were to fall over and crush a toddler or a pet. And so I think it's going to be a while before we actually see humanoid robots in people's houses, but they are on the horizon. I think it's a little ways also until we will see robot lawyers actually appearing in courthouses. I think one of the things we need to all keep an eye on, though, is some of the risks that AI is posing to society. And many of the risks that I worried about when I wrote my book, Mastering AI, that came out not very long ago, it came out in the middle of 2024, I'm afraid I have to say that some of those things that I was very concerned about are already coming to pass. One is in the area of mental health, where we are seeing some serious problems with AI chatbots that have reportedly encouraged people to commit suicide. We have issues around AI companions that are replacing real relationships. There's also a phenomenon that is now being referred to as AI psychosis, where people who have extended conversations with chatbots become delusional. Sometimes they buy into conspiracy theories. This is becoming a real phenomenon. There's also a lot of concern about what's happening with cybersecurity. As I mentioned, Moltbook was full of cybersecurity problems. There's also a recent case where Anthropic found that a Chinese hacker group had used its AI model Claude to run attacks at scale against the critical infrastructure in Vietnam. And I think we're going to see more and more of these kinds of incidents going forward. AI is being used in scams of all kinds. Some of the most worrisome, I believe, actually involve voice impersonation. Now, the deep fake I showed before, I thought the voice wasn't great. It didn't sound exactly like me. I think my kids or my parents would know that that wasn't me. But some of the voice cloning is so good that it is able to fool people's close relatives or colleagues. And there have been cases where people have received a phone call from what they thought was their son or daughter saying they'd been arrested or were being held hostage in some kind of situation. And could the person please send money immediately to the following bank account? And people have done this. There's also been some cases where the payment departments of large companies have been tricked into thinking they were talking to the CFO or the CEO of the company, ordering them to make a payment to a new account or a down payment on some sort of transaction. And the finance department has passed along those payments, and that's becoming a problem. There's the whole issue of how AI is starting to impact our cognition. Multiple studies have shown that people who use chatbots for any task, whether that's coding or writing or analysis, they do tend to actually see some de-skilling. And certainly when we're learning a new task, there's lots of evidence that it hurts our ability to learn new skills if we rely on AI to do that. Terence Tao, who is perhaps the world's greatest living mathematician, has found that AI can help him sound some of the world's toughest math problems, but he has recently faulted AI for skipping key explanatory steps that he thinks are critical to real understanding and also helping him discover new knowledge. It's harder to build on AI's insights because it often doesn't explain what it's doing well enough. In schools, we need to be really careful. There have been some very good studies over the past years about how AI is affecting education, and AI has the potential to be an incredible boon to education if used correctly. It is possible to create versions of these chatbots where they essentially use Socratic method. They prompt the student to think, but they don't give the student the answer, and they aren't being used to cheat. But of course, there are many cases where students have used these models simply to do the work for them. There was a large study conducted by the University of Pennsylvania that involved more than 1,000 high school math students. It was actually conducted in Turkey. But it was a randomized controlled trial. They gave some students access to ChatGPT and said you can do whatever you want with it. They gave some access to a model called GPT Tutor that had specific pedagogical guardrails around it so that you could not simply cheat using it. It would not just give you the answer. And they had some students who had no access to AI at all. The group that had access to just the standard ChatGPT group, when they were subsequently tested, they improved their grades by about 48%. The group that had access to the specific GPT tutor application improved their grades by 127%. But what was interesting is then when they tested the students without access to the AI for exams, the standard GPT students actually performed 17% worse than the students who had never had access to AI to begin with, which gives you some evidence that if you don't do this correctly, and if you allow students just to use this in a way where it gives them the answers too easily, it actually harms skill acquisition. And I think we're going to have to think about how we do this when it comes to other fields as well. And I'll talk about training in a moment. Specifically, there have been some studies about the use of chatbots in law schools. They found that access to a chatbot or one of these large language models tended to improve the speed at which the law students could do legal analysis and produce research. But it had varying impacts on their actual understanding of what they were researching. It tended to help actually the students who were already worst performing the most. It lifted their scores on certain tasks by about 48%. The students that were already at the top of the class, however, in law school, tended not to see much impact at all from the use of these AI assistants. We need to also watch out for the economic effects of this technology. Here, the evidence is mixed. You have some tech companies saying that they have seen so much productivity gains that they've started to lay off workers due to AI. But there's some suspicion that at least some of this involves what's being called AI washing. That's the idea that attributing cuts to AI makes a firm sound cutting edge while distracting from the fact that they actually had overhired or made other bad businesses. That said, there is starting to be just a little bit of evidence that when it comes to at least a few fields like software development, and especially when it comes to the hiring of younger software developers, that AI is having impact and firms are cutting back on the hiring of junior software developers because AI is able to take on some of the tasks that those junior folks could do before. Turning to AI in the law specifically, there are opportunities and perils here. What does this all mean for the legal profession? Well, in law, despite some dire predictions in terms of the economic impact, hiring seems to continue. Some of the world's largest law firms continue to hire the same number or even more junior associates, even though they have cut back on back office, administrative, and support staff. And you will have probably seen that there were some recent headlines around Baker McKinsey making rather drastic cuts to support staff and administrative staff, but not to their core group of lawyers. I think Clifford Chance, you've seen similar headlines about. David Autor, the labor economist who I interviewed for my book, he argues that most professional services, and law would certainly fall into this category, are actually supply constrained, not demand constrained. So delivering a service more efficiently with AI simply results in more consumption. And I think that's something we're probably going to see going forward. If you think about the tasks involved in law, there's some interesting research about the extent to which AI can automate those tasks. Anthropic put out a report just 2 weeks ago looking at the exposure of different fields to AI, both in theory and then what they were actually seeing so far in practice. When it came to sort of legal tasks, Anthropic judged the theoretical exposure, meaning what today's best models could potentially automate, was at 88% of tasks. But then when they looked at what was actually being done, it was only 15% of legal tasks that are currently being automated. They've also published some data on how much of the sort of agentic use of AI with their Claude models is currently legal work. And it's a very small percentage. It's just under 1% of all usage, all agentic usage, I should say, of Claude right now is for legal use cases. But the capabilities are real and improving fast. OpenAI has a benchmark called GDP-Val, which you can find on the AI repository Hugging Face. And I encourage you all to go there and actually look at that portion of this evaluation that deals with legal tasks. There are several complex legal tasks that are part of that benchmark. One is a complicated estate planning matter. There's several corporate and security law scenarios, and there's a privacy case. And on this benchmark, the best model evaluated to date, Claude Opus 4.5, scored as well or better. And they benchmark this. There's a gold standard benchmark for this where people are, the models are benchmarked against professionals with experience in that field. And in this case, they say that they used lawyers from top 100 law firms as rated by American Lawyer, one of these rankings, to do the benchmarking. So Claude Opus 4.5 scored as well or better than these human experts in 73% of instances. They were actually judged better than the human experts in 35%. On the others, they tied. OpenAI's GPT 5.2, which is the last model for which they've published full benchmarking data for this, was at about 66%. Walters Kluwer, future-ready lawyers, did a survey that was published earlier this year that reported that 90% of lawyers are now using at least one AI tool, with about 62% saying they're seeing time savings. And the time savings has ranged between about 6 and 20% of the time it took to do that task previously. We're seeing lots of specialized tools come out for legal research. There's Harvey, there's Counsel, which is part of the Thomson Reuters empire, there's Bloomberg Law. But many lawyers are simply using ChatGPT or Claude, often in an enterprise setup of those tools. A 2025 benchmarking study by Val's AI tested legal-specific tools and general-purpose AI agents against human lawyers on 200 legal research questions drawn up with input from major law firms, including Paul Weiss and Reed Smith. All the AI tools outperform the human baseline across accuracy, authoritativeness, and clarity. The legal-specific tools scored 76 to 78% in terms of their overall performance, against a baseline accuracy number of 69% for the human lawyers. But there are downsides, of course, to using these tools. And the biggest one is the danger of hallucination. There's been studies that have found that even some of the best legal tools still hallucinate about a fifth of the time, which is not great news. If you're trying to use these, it means you have to spend a lot of time trying to verify what the tool has produced. There are at least 550 cases reported globally of lawyers caught citing fake cases, including more than 350 in the US. There was a case in California last year where a lawyer was fined $10,000 by an appellate court for submitting a filing with 21 false citations. Judges have threatened serious sanction and even disbarment for lawyers who repeatedly submit documents with fabricated citations. There are opportunities here to use AI for drafting and contract review. It can help find, aberrant clauses, things where the contracts may differ. It's very good at this. But even here, professional judgment still matters. And it turns out that senior lawyers consistently get more value out of using these tools than junior ones because they have the professional skills to evaluate what AI is producing. The question of what good looks like still requires human expertise. And one of the most interesting areas that a lot of large law firms are working on is whether they have kind of deep libraries of contracts that are very unique to them, where they might be able to fine-tune models to make some of these professional judgments in a more automated way, and where they might have a competitive advantage. Obviously, we're seeing big transformations in back office and administrative function at law firms, things like billing, invoice processing, and I think we're seeing a lot of firms start to lean into that. Some of the more out there kind of interesting uses of AI are in things such as jury consulting. It's possible now to create AI personas that could stand in for human jurors, and instead of impaneling a mock jury involving real human actors, or actually selecting people off the street to serve in these mock juries, it's possible to create a virtual mock jury. And I've heard that some jury consultants are starting to do this. There's also software like Predicta, which is a software program that claims it can predict the odds of success of a particular set of arguments before a particular judge. So I think we're starting to see a lot of these very interesting use cases. One of the things that AI is doing is potentially democratizing access to the law, which sounds great. But I do think there's an issue where you have more non-lawyers trying to do legal work with the help of AI tools. I think you're going to have more people trying to represent themselves pro se, and I think this is going to raise all kinds of issues. And I'm sure you'll probably talk about that more later today. One of the things I'm starting to see is that you are seeing new business models come up for law firms and new kinds of law firms that are trying to essentially democratize access to legal services. There's a company called Law Hive that is focused on the retail legal market, This is wills, simple contracts, employment agreements, home purchases. And the idea is that they are employing human lawyers, but they're also using a lot of software. And they're making the decision of what needs to be done by the human and what can be automated completely and where the human lawyer needs to be augmented. But the combination of this is that they can offer these services at a lower price point. There's another company called Robin AI that is doing a sort of similar thing, but aimed at the higher end corporate market and is proving particularly popular with in-house legal counsel, who and it's essentially just like using another external law firm, but at a lower price point. So I think we're seeing all of these interesting developments in AI and law. And I know I'm running a bit low on time, and we want to get to questions, so I'm gonna speed it along here a little bit. One of the things I think we're interesting to see with these new business models is what does happen to the billable hour. I know it's been predicted for years that the billable hour was going away, but maybe with AI, it is actually starting to happen. We have questions around that training. How are you going to train junior lawyers if it's actually the most experienced lawyers who get the most out of using the AI tools, and the AI tools are increasingly taking over the work that junior lawyers used to be given as part of their training? Well, some firms, such as Ropes and Gray in Boston, are starting to give junior lawyers dedicated time set aside for learning to use the AI tools. Some firms are saying they're still hiring junior lawyers, but they're not going to bill for their time or not bill as much, while they're increasing the rates at which they bill out their senior lawyers. And I think seriously, one thing that may happen is that a lot of firms will start to rethink training and return to essentially a 19th century apprenticeship model. If AI is taking over many of the routine document review and research tasks and legal memo writing that was traditionally the bread and butter of junior associates' work, firms may hire fewer junior lawyers, but have them train essentially just at the elbow of a senior lawyer, much the same way you might have seen in much smaller firms in the 19th century. So I think we're seeing all of that happening. I wanted to get very briefly to the issue of bogus evidence, and we started with the deep fake. And I think one of the big issues that are going to confront courts is that AI has gotten very good at creating fake videos. And I think I just going to roll one example here very quickly of a video created with Sora, an AI tool that OpenAI debuted. Can we run the video? This is Sam.
Please, I really need this for Sora inference. This video is too good.
So that's just one example. It does really look like CCTV footage that was created using OpenAI's Sora video app. It has a watermark on it that says it was from Sora. It has some metadata that watermarks it, but it's pretty easy actually to remove that. And I think courts are really going to be challenged in the future by people submitting evidence that may or may not be real and not having enough access to technical expertise to vet all of this. And you're going to essentially have experts from both sides claiming different things, and it's going to be hard for courts to work this out. So I realize I'm running a little bit low on time here. I'm just going to jump ahead. One of the things we're really seeing that is concerning is the use of facial recognition technology. Increasingly, police departments are using this technology, often not disclosing the use of it. And when the Washington Post did some research looking at this last year, they were able to find a number of departments where they made arrests solely based on facial recognition, despite the fact that departments often had policies against doing so. They were able to find at least 8 people in the US who had been falsely arrested because of facial recognition technology. A big problem with facial recognition technology is that it does not perform well, or as well rather, on dark-skinned individuals. And that's a known issue, and yet police departments have continued to deploy this technology. There's been similar issues raised around technology that is supposed to help judges with sentencing decisions or parole boards with parole decisions. These technologies promise fairness, but they often bake in historical bias. And again, when investigative journalists have looked at the use of this technology, they've tended to find that it's still disadvantaging defendants who come from who are racial minorities or come from disadvantaged backgrounds. And I think that's going to be something the courts are going to have to wrestle with as well going forward. These examples from the bleeding edge of AI's use in the justice system really bring us back to Alan Turing and Joseph Weizenbaum. I think we really need to keep in mind what intelligence is. And if we don't know, we need to be very mindful about the use of this technology. And we also need to be careful not to think that just because these systems are excellent mimics of human outputs, that it means that they're actually intelligent. We should avoid being pulled into the Turing trap of seeing this as a contest between man and machine, where we are looking to create robot lawyers, or worse yet, robot judges. This gets at a core question, which is what purpose does the law ultimately serve, particularly in a criminal justice context? Is what we crave perfect fairness delivered by mathematical calculation, or is it something less perfect, but humanly perfect? The assurance that our case will be heard by a judge whose wisdom is born of both learning and lived experience, who can apply empathy because that judge is human. They have lived and they know what it is to be human. This is what Joseph Weizenbaum believed, and this is why he said that AI should not sit in judgment of human beings in areas of the highest consequence. When Weizenbaum first proposed drawing clear boundaries between what we wanted humans to do and what we would permit machines to do, he was dismissed. The reason is the machines weren't capable enough of the things he was worried about anyway, so people said, why get so worked up? But now AI can do those things, so we need to decide. Where will we allow this technology to tread, and where will we draw boundaries? You're all lawyers, so I must say, we really need laws here. Or at the very least, we need enforceable standards and rules. We must aim to govern this technology, to master it, before it masters us. That is actually entirely doable if we act now. We still have human agency, and I would urge everyone in this room to use it. Thank you for listening, and I'm happy to take questions now, or I can answer some later online. I know I went slightly over time.
Pepper Firestone. I'm a judge in Henry County, and I am one of the 2025 fellows, and we have time for about one question. So does anybody have anything they'd like to ask? I know that was a lot to take in. I got one right here.
Good morning. My name's David Corliss. I am not an attorney or member of the bar. I'm a technologist working in AI consulting on this, statistical expert witness and advocate, that kind of thing. You had mentioned putting guardrails around AI and places where it goes wrong. This is something that I do, I teach, I research. But let me ask you this question. It seems to me, my impression, and again, I don't come from the legal background, I come from the technological background. It isn't so much a matter of we have to put all these guardrails on AI, but rather not drop the guardrail that we've always had. No one would, I would think, 50 years ago, think of submitting a bunch of court cases in a brief and not checking the citations. No one would submit code for production and not have a person check it. It's the human in the loop. Is it a matter of adding guardrails, is my question, or simply not dropping the guardrails we've always had?
Oh, that's a very good question and a good observation. In some cases, that's exactly right. We have these guardrails already in place. But I do think the fact that you are not doing some of the work yourself as part, you're handing some of this off to the AI model, and the outputs are generally, they look good, they kind of defeat a lot of the proxies that humans use to determine when something is of poorer quality, because the structure and kind of the superficial look of a lot of what AI produces is excellent. But it turns out if you probe it, it can actually fall apart pretty quickly. It can be full of hallucinations. But I think that the fluency of the outputs of AI tend to lower people's guard. They tend to defeat what we've learned about how you test for accuracy, when you should raise your vigilance. So that's one problem. I also think that when you place humans in this role where they're only verifying things, and when they're trying to verify something that is mostly right, maybe it's only going to be wrong 5 out of 100 times, which is, or still a decent error rate. And if you're gonna be in that sort of situation, humans let their guard down. We're not very good at maintaining vigilance over long periods of time, particularly when reviewing things that are okay most of the time. And I think that's the problem that AI is presenting. I think we need to come up with new verification systems. Some things maybe even as simply as a checklist, like constantly remind people, like, have you checked every citation in here? You have to actually physically, check a box somewhere that you've done that. That could make a difference in some cases, because if you don't do that, people they let their vigilance down, they let their guard down, and that's where errors come through. A lot of getting this right really comes down to a lot of things we have learned about human-computer interaction. And there's a whole field of study, and actually not enough insights, I think, from that field of human-computer interaction have been brought into the new world of kind of AI human interaction.
Well, I hope you all join me in thanking Jeremy. This has certainly been a fascinating conversation.
Well, thank you all.
We certainly have a lot to be excited about in this conversation and several things to be pretty concerned about. So it will be interesting to kind of walk through a few more of these conversations today and unpack all of the sides of this perspectives. So next up, we have our first panel, Practicing Law in the 21st Century. We will explore how law schools are integrating AI into their curricula and preparing future lawyers, how AI intersects with lawyers' ethical duties, and how to manage all of this in a modern law firm. I would like to introduce our moderator, Jay Wampler, Assistant Disciplinary Counsel of the Supreme Court of Ohio and Fellows Class of 2020. Jay has merged his passion for technology and AI since joining the Office of Disciplinary Counsel by conducting numerous CLE presentations for Ohio's judiciary, law firms, seminars, and more. Please join me in welcoming Jay.
Well, thank you, Lori Beth, and thank you, everyone, for being here today. It is truly a privilege and an honor. I do have to have these on the side. My apologies to all. Practicing law has changed so much recently, as we heard Lori Beth say at the outset. Mr. Hollingsworth also spoke to it, and Mr. Kahn as well. And where we are now, the rise of AI, we're seeing that impact across all professions, from the classroom to the boardroom and now to the courtroom. And in light of that, during this panel, what we hope to have in this discussion is really a takeaway about the AI revolution, how it's changing the way that we're teaching law, how the way it's changing, we're practicing it in our law firms, whether we're solo, boutique, or a big firm. At the end of the day, it's also affecting how it's getting into our courtrooms and what the court is going to be doing about that. So without further ado, let's get right to the introduction of our esteemed panelists. Immediately here on the far left, we have Rebecca Fordon. She is the Assistant Director of Innovation, Research, and Instruction at the Ohio State College Moritz Law Library and the Moritz College of Law. She teaches legal research and legal technology with a focus on the practical integration of generative AI in law practice and in education. She frequently writes and speaks about the evolving role of AI in research methodology, AI literacy, and the function of legal information, and has earned national recognition for her leadership in these areas. We welcome you, Rebecca, and thank you for being here. Next, ladies first, if you don't mind, is my friend and a colleague, Sarah, also known as more commonly Sadie Moore, from Fisher Phillips. She has decades of experience crafting practical solutions to legal challenges faced by private and public employers, both in union and non-union settings. And she also is sought after for her leadership in addressing new era topics, including AI integration and international threat assessments. So welcome, Sadie. And last but certainly not least on our panel, we have the Honorable Judge Scott Schlegel, who comes to us from the Louisiana Fifth Circuit Court of Appeals. He is a recent inductee to the Louisiana Justice Hall of Fame. And Judge Schlegel is known for designing and managing one of the most advanced courts in the country for delivering legal justice online and technology. He's received numerous awards and judicial honors and is nationally recognized as a speaker on legal tech and modernizing the justice system. And as a side note, I am also a subscriber to his Schlegel Tech blog, so I'm honored to have him here and introduce him. So we welcome our panel. Thank you so much for being here. So we'll start first in the classroom, and let's go to you, Rebecca. How should law schools balance teaching those traditional attorney skills, right? Legal analysis, judgment, writing, even legal research, and juxtapose that with preparing students to use AI responsibly in practice?
So I guess that I think...
Yeah, you might want to hit the buttons for the green lights.
Okay, good. I guess that I think that they complement each other, and that I wouldn't say it's necessarily like an either or a balance. Like, we are not able to use AI well unless we have those traditional legal skills. Oh, thanks. So, like, for example, in the area of legal research, I won't be able to recognize whether a case is on point or whether I've found all of the cases in my area of law, or if one case is more persuasive than another, or what the controlling law is. Like, those are all things that I need to be able to do to assess AI output, and those are all traditional legal skills. So part of it is that we still need to focus on those traditional legal skills just as much. However, there is this new component that students need to know a little bit about how AI works, and get some reps in on using it in law school. I think I have heard that some law firms are kind of hoping to shift maybe some of the junior skill experiential learning that might normally come in the first few years of practice, like kind of towards law schools. So I think that's something we need to think about too, and it actually nicely complements what's happening with the Next Gen Bar right now, where there is a bit of more of a focus on like practical skills, and law schools are caring more about that. And I'll also say that students are very cognizant of this as well. I see students come in really worried about using AI, especially in their first year of law school, because they're there to become lawyers, and they're spending a lot of money to come there and become lawyers. And so they want to learn that. They came to law school for a reason, right? They want to change the world. They want to help people. And they know that relying solely on AI isn't going to do that. Like, that's not going to get them where they want to be. We heard from our keynote speaker about kind of like the dangers of offloading some of that cognitive function, and that's very real, and I think our students know that as well.
Thank you. Sadie, let's go from the classroom to the law firms then. How are we seeing AI show up in law firms these days at this point?
Well, Jay, it depends on the law firm. So at Fisher Phillips, what we've done is we've packaged ourselves as a technology firm that just happens to provide legal services. And so if you go to the website, it doesn't look like your traditional law website, and that's purposeful. In terms of the students coming in, a number of years ago, our firm had worked with Counsel to rigorously test that platform, and then was one of the first to be involved in deploying that platform. And at the same time, we also had a mentor program that was implemented that became a very high functional touching base between people that provides that skill set that is feared to be lost through the AI process. So those deliberate moves have been done to try to stay ahead of the curve, while at the same time creating internal supports that ensure that everyone's on the same level playing field. To accomplish that, there is a knowledge management team, and that team is specifically tasked with AI. And what do? Well, they're the ones who are doing all the testing. They're the ones who are doing the deployment in terms of the training. They're the ones who are monitoring as we go along because of the updates that happen, and helping us to understand what are the platforms that are authorized, the ones that are authorized, how we are allowed to utilize them, because we're not using all platforms on a full basis. There are some that are utilized on a very limited basis. Claude, that you spoke of, we're not allowed to use that. So our knowledge team is very robust with how it is approaching things, and really is our eyes and ears. And in doing that, it allows for generative AI for our team to be a coworker. And that's how we view it. It's not a replacement. It's a coworker that supports efficiency and strategic insight, not decision-making, insight. And it's a very powerful tool.
As a follow-up, if I may, then, Sadie, staying with you for that, is Fisher Phillips using, or law firms in general, as you're aware of, not limiting, but having, as you say, your coworker for non-lawyer assistance as well, and rather than just new associates or individuals who've been at the firm for years, are you also seeing that, or are there policies engaged in law firms as it relates to that user who can use AI?
It's a great question. So we, in our policies, have generative AI tools that are prohibited. Can't use them. Don't touch them. You touch them, you're out. There's one of those right now. We have DeepSeek. You use that, Your Honor. So we have those identified. We also have the limited tools that are identified. I just had a senior moment. What was the question again?
Really, as it also deals with non-lawyer assistance?
Yes, thank you. So all of those tools are rolled out not just for the legal purposes, but also as part of our business operations. And so in supporting our operations, all of our various teams have access to the various AI platforms to help them to be more efficient themselves and provide the strategic insights that then help our teams. For example, Lance Goddard is here today. He's one of our marketing guys, business development, and he utilizes AI like you wouldn't believe to get all these different insights that we didn't have access to before. And doing it in a way that ensures the cybersecurity policies, are followed, that ensures that the privacy issues and the copyright issues that are involved are followed. So it truly is an integration of the AI at all levels within the firm.
Thank you. Judge, this is kind of an overly broad question, I realize, but how are courts at this point, with all that you see nationwide and even in your court, how are they implementing AI?
Yeah, I'll answer your question at some point here. But the real question I always have is, first of all, what an exciting time to practice law, right? I mean, this is wonderful time to be a lawyer and or to be a judge. And so the real question I have is, I think everybody in this room probably says, you know what, lawyers should be using AI. Students should be learning how to use AI and Gen AI. The question for you is, should judges be using Gen AI? Low participation here. Judges use AI, yes or no? See? And frankly, the lawyer answer should be, it depends, right? It depends. And it depends in what situation. So, I was on the trial court for about a decade, and now I'm on the Court of Appeal. And so, I always ask people that say, yes, judges should use Gen AI, and I say, okay, great. Let's say that the judge is considering whether or not you get the children. Do you want to find out at some point that the judge used Grok and that he used Grok, so you lost the kids, but if he would have used ChatGPT or Claude, then you would have had your children. And I think the answer is no, right? That's not the social contract. We didn't sign up for this where we hand over the human judgment to the judges to turn it over to the bot overlords to make these tough choices and tough decisions. And whenever I hear people talk about the singularity and the consistency, I always ask, whose singularity are we referring to? Whose consistency? If you won, you wanted them to use Grok. If you lost, you wanted them to use Claude. And so this notion of human judgment can be just all thrown into a bot overlord and thank you. It's not a real thing. That's what mediation and arbitration is for. Go for it. But that is not the justice system. And so I think we need to step back and think about how judges should use it. And yes, judges should absolutely use it. And they should use it so that it doesn't take a year or 18 months for you to find out who gets the kids. You should use it to get to the answer maybe in 6 months or 3 months. And so how are courts using it? Right now, courts are dabbling. Courts and judges are starting to figure this thing out because it's not our job to be first. It's our job to get it right. And when you mess up, you get sanctioned. You get a pleading stricken. Big deal. You get embarrassed a little bit. When I make a mistake, that's the law. That is precedent. That is a bigger deal than anything else. And so I want judges to slow roll it. I want judges to have a lot of friction in their tools before you go frictionless. Great, design a frictionless system and then add friction back where it's necessary. So obviously using it in legal research, that's the easy one. And now that the AI is being built and baked into the tools that we use constantly and trust, you're seeing judges more and more start to dabble a little bit. Obviously, you should use it for, hey, did I make any mistakes? Build yourself an English major agent. Mine's called Danny. And have it review your opinions to see if you have any English mistakes. I mean, there's a lot of low-level, low-hanging fruit that you can use and implement it. So I like to break it into 3 kind of buckets. One is the administration of justice, the business side of it. You should be doing that all day, every day, and we can talk about examples of that forever. Then there is the kind of in the courtroom type discussion that we have. And, why are we not transcribing all of the hearings and sending it to you all before you hit the car and you have a sample order that is, you can talk to opposing counsel, send the transcript that's not certified to your clients and say, hey, I think Judge Schlegel's wrong, but his reasoning's pretty good. Here, client, should I take him up or not? You're not going to win this one. It's abuse of discretion. That'll save everybody time, money, and effort. You go certified if you need to. And then have the proposed judgment so that you don't waste time going back and forth with opposing counsel, because you know what happens when you send competing orders? I have no idea what I said. And I have to go back and listen to it. So it helps through it. And then the in-chambers. Should we be using it for writing? And I suggest you should never get past the white page problem and use the tools to give you a first draft, because then the tail is wagging the dog. And I don't care how good you are, you might start going left if you don't realize you should be going right. And that's good, that's good, that's good. It's your job is to be an advocate. So who cares how it leads you? It's our jobs to get it right, and so you never want a judge to get past the white page problem. So again, I can go on forever, but I think that's a good start.
Amen. So let's come back then, Rebecca, as we think about this from getting, into the classroom, how are law schools, and maybe specifically Moritz, but how are law schools really beginning to integrate, Gen AI in your curriculums, particularly as you were mentioning earlier about legal research, writing, prompting? I mean, are we even teaching AI prompting? I think that could be a great class.
Yeah, so law schools are doing a lot of things. I think there was for a little while like a hesitancy to introduce it into the first year curriculum for some of the reasons I mentioned earlier, like not wanting to kind of replace their own judgment and their own learning. But I've seen more law schools come around to that, and many are now including it in like the mandatory curriculum. And so you'll see things like, yes, like a prompting class, or the curriculum might include just some knowledge about how large language models work and how they can go wrong. Ethics, really important component. Legal research, yes. Writing, yes. So I think those are kind of the main things that tend to get covered in the first year curriculum. And some law schools are doing that in-house. So at Ohio State, we started a program for 1Ls this past year, and we have some amazing expertise within Moritz, and so we taught those modules ourselves. And I think that was really great because we know our students, we kind of know what they need, and we had that expertise. It is hard to scale that, and so I've also seen a lot of law schools bringing in kind of like vendors to help with that. So like Suffolk is one that, and they're a great technology school. Like they have a deep bench too of technology experts, but they are still bringing in a vendor to help with their first year AI, kind of like AI training. So there's a few different ways you could go with it. Another thing that a lot of law schools are starting to do is have their students actually build things. So at Moritz, we have a program called Justice Tech that Amy Schmitz leads there, and she partners with our engineering students, and they actually create things for people in our community. And that's a model that a lot of law schools are doing, and increasingly integrating AI, using AI as they create those tools. So one that they just came out with and is just, I think, going live pretty soon is like a tenant translator, sort of. Like tenants who need help with their speaking to their landlord don't always use like the right legal language, so this tool kind of helps them translate it in a safe and secure way so that landlords understand it better. And then I think that the third thing is there's a lot of new legal issues that arise because of the use of AI. And so faculty are on top of that, and I think that's where we've more like traditionally seen faculty interest in AI, and so that's continuing to go strong, and there's amazing work people are doing all over about like what does like how do liability standards change with self-driving cars, or how should our professional standards change with AI in the legal profession? So we're continuing to see a lot of that kind of work as well.
So this next question then, thank you, Rebecca, is really for Sadie and for Judge. You're now starting to see in your firms and in your courtrooms and even as law clerks, these individuals who are coming out that have gone through and experienced a curriculum with generative AI or AI in general. How are you seeing that impact, Sadie, the law firms, and then Judge, how are you seeing that as an impact with maybe your law clerks or judicial law clerks and young practitioners in your courts? So ladies first.
Darn, I was going to do rock, paper, scissors. So in the firm, we view it as everyone's on the same playing field. And by that I mean we assume we don't know. And so if someone comes in from law school and has that training that they're walking in with, we don't assume that that means anything other than they have a base of knowledge. We don't know how that knowledge translates relative to our platforms and how we implement the generative AI. And so it's important that when they come in the orientation, they are provided a very thorough training set relative to the generative AI that includes everything that we've gotten. And so as part of that process, we have internal and we have external on each of the different tools. And you know how you hear about in the medical field, the surgeries and how they have kind of the after, and they sit around and they, no pun intended, but kind of dissect themselves in terms of what they've done. It's very similar at the firm. So if there are practical implications of the generative AI, good, bad, and different, that people find, that is shared. There is a well of knowledge that is experiential. and provided to one another. Judge, I'm interested in hearing what's going on.
What's going on? Well, I think it's important to note that every firm, every court, every chamber should have an AI policy. And it doesn't have to be something fancy. It can be you cannot use it. I hope that's not the case, but at least it's a policy because people are using it, everybody's using it, whether you want them or not to. And so our policy is simply this. You may use it. You may use it in these situations. You may use these products only, and if you use them, you must disclose to the judge that you're using them. That's it. And then especially my chamber, I encourage my clerks to use the Gen AI tools because, again, it helps you get through the record. So on the Court of Appeal, I use it to chunk the record, and I encourage my clerks to chunk the record. So assume you get a 20,000-page appeal, and you've got to get through it. Well, rule number one with AI is don't use AI. Do your job first. Once you've done your job, then you start using AI. And so once I have a position or a direction that I want to go in, I'll use it to chunk the record. Summarize, list and summarize 2 or 3 sentences of all the witnesses who testified in that 2-week trial, and do the same for all the exhibits. And what that enables me to do is go, all right, well, these 3 witnesses were called for the proposition of X. Well, X doesn't matter to me because I'm ruling in favor of the plaintiff or the defendant, so I can ignore that for now. Same thing with the exhibits. Oh, these 3 witnesses were testified for this. Well, great. Then I can go and really pay attention and read all those transcripts to ensure that I get the summaries are actually correct, because hallucination is not just case law miscitations. It's contextually you didn't understand what that testimony was. And that's the most dangerous hallucination that no one talks about, is the misunderstanding of the summaries or the misunderstanding of the conceptions of those transcripts. And then from a trial court perspective, if I was a trial court judge, I would have every pleading, or have my clerks, or I would do it, I would have every pleading fed into a approved Gen AI tool and prepare a bench memo for me. And I do that too to get ready for oral arguments. But prepare a bench memo for me so that when I walk into those 10 or 15 pretrials a day, I can walk in and actually be prepared for you, the lawyers. And it doesn't matter if there's a few facts that are wrong, because you are going to correct the judge. But at least the judge can then go, all right, this is a car accident. Okay, we have these witnesses that need to be deposed. Okay, great, the value is X, Y, and Z. Here are the different injuries that exist. It just gives that judge a better understanding of the case when they walk in for the pretrial conference to say, all right, discovery is now in 60 days or 90 days, or I understand the complexities of it. Have you deposed that witness? Have you sent out your subpoenas? Where are we on discovery? All the fun things that we do. But again, using these tools to help us get in there. And then finally, from a drafting perspective, it's really good to simply, once you've done your job, not have it write for you. Hey, these 1 or 2 sentences, I don't really like that. Can we tighten that up a little bit? Or can we tighten that paragraph up? Or can you compare it to the record and see if I've missed any assignments of error, or if I haven't addressed anything? Again, I'm not asking the bot to do my job for me. I'm asking it to be another set of eyes, if you will. And I would never trade my actual law clerks for a Gen AI tool, but using them all in tandem because we understand the workflows is where the secret sauce of these tools are. You know how to do this. Breathe. We're gonna get through it. It's okay.
Absolutely. Judge, when I've had the privilege to go around and get to teach CLEs on AI with others throughout the state, typically the moniker I use is AH, always have a human. But it sounds like with what you were just saying, you're always keeping that human in the loop. Can you just expound on that for a moment?
Yeah. So I heard this gentleman say human in the loop, and I always say, that's what everybody loves to throw out. That's like a new term that everybody likes to say. I like to say the right human in the loop. And what I mean by that is my son's now a 20-year-old in college. But when he was 16, like a lot of kids around this country, he got a driver's license. And let's assume that someday I get to retire. The dream car is the Turbo S 911, right? Let's assume that I had this when my son turned 16 years old and he goes, Dad, I got a hot date tonight. Can I borrow the Porsche? And I go, you know what? You're a licensed driver. Here you go, buddy. And I toss him the keys. What's going to happen? He's going to wrap that car around a tree and hurt himself or that girl he's taking on the hot date, right? I use that to say, just because you have a law license or just because you're a judge, for the love of God, don't use an unhinged Claude to write your opinions or to file something with the courts because you're not ready for it. And if you're a labor law attorney, don't go use it for a med mal case you know nothing what you're doing about it, because these tools are so powerful and so convincing that you are going to go in a direction where you're wrapping that car around the tree. And so if you keep the right human in the loop and understand the strengths and weaknesses of these tools, you'll be okay. And the final comment I always like to say is, y'all remember 25 years ago when that crazy lawyer came up to you in a conference like this and said, hey, come over here, I want to show you something. I got my client files in the cloud. And we all looked at that lawyer and say, what are you talking about, the cloud? Yeah, my client files are all up there. Like, you're going to jail. You're losing your law license. What are you talking about? And the point I'm trying to make is that what we understood then that was a lesson today is don't use free. Free is bad. Don't put confidential records into these LLMs like you wouldn't put in a Dropbox unless you have the right licensure, the right enterprise level. And if you're going to use medical records, you need to make sure it's HIPAA compliant, cloud-based. And so the lawyers that aren't using cloud-based solutions now are probably the ones committing malpractice. And I suggest to you that the ones that aren't using LLMs in 5, 10, 15 years are the ones that are not doing their jobs. And so we've done this before. We'll do it again. We're good. Just breathe.
Thank you, Your Honor. So Sadie, in keeping with that, and then Rebecca, I'm going to come to you on this. If we're going to use what Judge says and have the right human, some of those humans, though, that are walking into our law firms are clients. And now they have access to the free. And some have decided to upgrade and pay. Given that there's also that juxtaposition in the law with law firms of competing. If I had a firm in your firm and I want to compete with Fisher Phillips, the push to provide clients with better, more, bigger, faster, stronger, so that I can deal with more things and more clients. How are law firms handling that? The client that's walking in, that human who is now armed with AI, along with that competing interest of, capitalistic to do best for my firm and my clients to move forward?
It's a great question. And we take the same approach that we do with the young lawyer coming in. We do not assume that the client knows anything about generative AI, its capabilities, how we use it, whether we're going to use it in their case. We spend time with the client being very transparent with what we use, why we use it. And there are clients, particularly insurance companies, that have data processing agreements with us, and those agreements don't allow us, in many cases, to utilize the generative AI. And so there are lots of kind of different pathways that we have to go down with the various clients. For example, we get to the litigation stage, we have a whole team that is devoted just to customizing the generative AI tools around the litigation to ensure that the client is comfortable, that we're complying with the court orders and rules, and that we are presenting things in the most efficient way. And so it depends. Just on, as you said, Judge.
There it is.
Yeah, I'm guilty. And so it's a step at a time.
That first thing in law school, right, Rebecca, that we teach is it depends. Every lawyer in here walked out with it depends that day. Mom, how's law school? Well, it depends. So keeping, the idea here from our courtrooms and using AI and understanding that we have the right human there, that we have the right human and we're dealing with other humans who actually believe that they're right. What about the humans that are the right humans that are in our classrooms? I had an opportunity to speak with a group of law firms, and they were very concerned with cognitive erosion, Rebecca. Mm-hmm. And so when we heard Mr. Kahn, Jeremy, talk about it a little bit, that when AI is used, it has that tendency, or overused for reliance, it can erode that judgment. So how are law schools addressing that issue of cognitive erosion to ensure that the individuals it's putting out, those right humans to use these tools, still have that judgment, still have that discernment?
Yeah, I think part of it is teaching the judgment explicitly. So we heard like our keynote speaker talk about like the renewed importance of verification, and so I think part of it is where do these AI tools fit within our current workflows, and where can they be useful, and where do they introduce new risks? So like in the legal writing process or in the legal research process, you want to start with like what is the human work. The judge, I think, said it well from the point of view of the court's work, that you want to start with your job. So like we focus in law school on reading the cases. You still need to know how to do that, right? And so like that's still where a lot of the focus is developing that judgment, developing your analysis skills, so that when you do use a tool, you can use it to kind of support you rather than replace your judgment. But I do also think that there is a risk that, and we heard our keynote speaker say this as well, that when you start to use tools to automate your work, that you rely on them more and more and more. So I've definitely even seen this in my work, that you start off saying, okay, write me, maybe help me with an outline, and then it goes from, okay, well, you could just maybe write like the introduction for me. And so after you see it perform okay on a few tasks, you maybe start to trust it more and more. So I think for our students, we want them to know where things can go wrong and where they're more likely to see bad results. So I think there's nothing more that Westlaw and Lexis would love than for us to start trusting them with just like, here's our legal issue, and they'll just output the whole memo for us. And they're really trying to like keep you within that product and keep you like, oh, you can double check it right in here. You don't have to go read all those cases. You just get your memo and then you click verify, and then you're kind of done. And so we want our students to understand that it's not enough to let the computer verify it. You are still the one who is responsible for reading your cases and for making sure that the analysis is complete. So I think that AI has a place in that, but it's not, it doesn't supplant it completely. As far as like practically where we see AI show up in those courses and how we keep it from taking over, I think one approach especially for first year legal writing, is just to say, you know what, for the first few months of this, we are not going to use AI. And that might mean having to do more in-class exercises rather than have them take home things, because there may be a temptation to use AI in those cases. So if they're kind of doing it in class, you maybe have a little bit more insight into it. For research, I think similar, like I teach more explicitly some of the tools like secondary sources. I kind of like lean even more into it, that they really need to understand how to use these sources to expand upon what they're getting from the AI response. But I think legal writing is maybe shifting a little bit. I wouldn't be surprised if the legal writing programs start changing even more, and there's a lot of discussion of that. But for now, I think a dominant approach is kind of teach the skills first and then use the AI to like supplement them, or supplement them, I should say.
Some need to be supplanted.
Then let it take over.
Sadie, what about, as we think about whether it's taking what Rebecca just shared, if I'm a solo practitioner, or if I'm a firm like Fisher Phillips, are there concerns about this new buzzword? I know that Stanford came out with it, and Columbia also, in their law review articles, talked a little bit about this new buzzword, cognitive erosion. Is that a concern that you're seeing at the law firm level? And if so, how is that being addressed?
So I remember in college going into the library and picking out books and flipping through pages. And I can't imagine being in law school right now. I would agree there's a level of cognitive decline, but I'm sure that the people who are no longer with us when I was, in law school, that they felt the same way because, that was in the 90s, that's when the Boolean, searching and sort of thing was just being introduced. And they thought there was cognitive decline, and maybe they were right, but I think some of that is automatically there as an assumption. What I think is lost in the AI relative to the younger generation is mentoring and teaching is experiential in nature. And yet you can't teach experience. You just can't. They don't believe you till they go through it, right? And how they go through it now is so very different. And we are counselors at law. That's relationships. The AI, while it has emotional intelligence, it does not have the experience of relationships and emotions and issues and disputes and how to find middle ground. You just can't convince me that it does or that it will do it as well as human beings do it. And I hope that remains true. So with the mentoring, I think that it's really important that we not only focus in on helping support with the writing, but help people understand how to have a relationship without a phone. I can't believe I'm up here without a phone. Oh, wait.
I got two right here.
Well, Judge, the same for you. From the judiciary's perspective, I mean, how do we, with this increased presence of AI, and it's been around for a long time, but now it has more of the ability to generate things and do more, even like my Tesla, when I press a button, it can drive me to work. How can we be how can we assure or work in our courtrooms and in your chambers, nationally and personally, to help allay these concerns of cognitive erosion that might be occurring due to reliance on AI?
I mean, it's a real question. And, I always go back to the big questions, the why questions. They're always important to me. I mean, I love our profession. I think justice matters. And so, this whole, if you ever tried a case, you always use the whole, you can't microwave justice. Thank you for being here, ladies and gentlemen of the jury. It'll take time. And I think it's important for us to remember that as we're going down this road and remember what we're actually doing here. I mean, again, we're talking about people's lives, people's children, people's livelihood. I mean, there's so many things that matter. And so I think the ones that don't care, and I don't mean it in that way, but forget about the why, are the ones that are going to get themselves in trouble and hurt the profession. And I think the judges, if they don't pay attention, will hurt the profession even more, because what is justice? And so I fear this cognitive decline, and I am a firm believer in don't touch Gen AI until you have the scarring necessary to understand it. I mean, I'm sorry, but I probably prepared, and I'm sure everybody in this room prepared for 50 or 60 witnesses before you took your first witness. And I'm not saying not use Gen AI to reduce it to maybe 20, but you need to do the hard work. I'm sure there's plenty in here that spent weeks in the dungeon looking through boxes of documents. It's not the most efficient way, and I'm not suggesting we go back to the dark ages, but you don't know the balance until you know the balance. I I speak frequently about how when I was a young prosecutor, I was asked to third chair, you heard it right. I was asked to third chair a horrific multiple homicide with DNA everywhere that was covered by a fire. I had no idea how to try that case, but you know what I knew? PowerPoint. And so I was the young buck, and I came in here and I was like, listen, Mr. Billy Bad Prosecutor, I know how to present all this evidence to the jury. There's so many things. So I got this great PowerPoint, and I had the slides, and I had the DNA on this thing, and it would shoosh, and have the next DNA, and it was brilliant. The problem is the guy who actually knew how to try a case couldn't follow me. My timing was off, so I couldn't follow him. And what mattered was the actual law, not the PowerPoint and the actual presentation of evidence. But the flip side of that is I had another homicide, and this was before cell towers were a thing. And they handed it to me because I was the young buck, and I figured it out because the guys who knew how to try cases couldn't figure it out. And I was like, the murder, he was here, and I tracked his entire flight. So there's a positive to it. But you don't get there until you try cases. You don't get there until you take depositions. You don't get there until you get a good shouting at from a partner, right? You know, you don't get there. And so what is the balance? I don't know. But I don't think that the folks in the beginning should be heavily relying upon it, because you can't figure this thing out because it is so nuanced. And the men and women who understand the nuance will crush anybody who doesn't, and I don't think they're gonna lose any cognitive anythings. I mean, you're gonna unload what you wanna unload. To your point with the self-driving cars, if you haven't pushed a button to have it drive you to work, it's amazing.
Yes.
But the cognitive load issue. All right, how many of you all are right lane, 3-lane highway, how many are right lane drivers? How many middlers? How many lefters? There's my people right there. All right, so if you hit drive me to work, that car will take the lane that it wants to take. And you fight it for a while, right?
Yes, sir.
And at some point you're like, who the heck cares what lane it takes? I'm getting to work. So that cognitive load is unnecessary, and it's good to hand it off to the Gen AI. But if you take the same path to work, so I have a path to work, and you know that bus stop that bus always stops at when you're away to work? The Gen AI doesn't have vision like you have. It doesn't understand. So the car will get behind the bus even though you know it's going to stop.
Yes.
Well, come on. So I just take over when I see the bus because I'm not waiting for the bus because, again, I'm a left lane driver. And the point is, it doesn't have that vision. It doesn't have that. So some of the cognitive load we want to unload. Some of it, you know, doesn't matter if I wait 2 or 3 minutes. Maybe, maybe not. It depends, right? And the car drives the same in the rain as it does in the dry. And if you let it and over-rely upon it too long and it's driving the same way in the rain, you better take over faster and sooner. And I don't think you're going to get that nuance until you have been scarred.
To that point then, Judge, as we go from cognitive erosion, it sounds like that could be, if I don't have that scarring, I could get a penalty of some kind. I could land it, right? And we're going to come right down the line through judges' perspectives, the law firms, and the schools. But, you know, Judge, first, you know, what do you believe the penalties are when AI is used? And by way of example, there could be information that's correct, right? We've all heard of the Mata case, and we've heard of other cases that are coming out. Now we have federal judges on a routine basis, unfortunately, who are either themselves victims of this, Your Honor, or citing multiple different lawyers for routine uses of this. So what do you think the penalties of AI use or overuse really are at this point for the profession and those lawyers and judges?
So this is a great debate amongst all the judges across the country. And the Mata case was, what, almost 3 years ago now?
Yeah, about 3 or 4, yeah.
How about this? Stop it. Just stop. Read the cases. You know, the answer, in my opinion, is so what? You know, I mean, it's a competency issue, and I don't mean so what in that sense. I mean, it matters. So, you know, you should be held accountable. Every state and across the country has a Rule 11 or its equivalent, so you're going to be held accountable. But have lawyers ever lied to judges before? No, right? Have they ever misstated the law before? No. Have they ever cited something and put ... where it was notwithstanding the provision before? Y'all have been doing this the entire careers. To me, candor is the problem, not competency. And no, I'm not excusing competency, but you should get hammered and dealt with harshly if you lie to the court. If you make a mistake, it's not the end of the world, in my opinion. Again, that can be dealt with a simple admonishment. Maybe you go take a CLE. It's the lawyers who don't own it. So we've had several situations in our court. One lawyer was sanctioned at the trial court level for clearly using Gen AI and with hallucinations. They refused to own it, got sanctioned by the trial court. They took a writ to our court saying that's not proper sanction and still wouldn't own it, and that lawyer was obviously referred to the bar, and the sanction was upheld. We had another lawyer who caught it before the court, wrote a letter to opposing counsel, wrote a letter to the court begging for forgiveness, making the correction. Oh, good. No big deal, because that is oopsie, and you own it. I mean, and obviously it's going to be judge dependent, but I think if it's not an issue of candor and you own it and don't make, 27 mistakes and you make one, it's a difference. So I guess it depends, and and then I ask judges, for the love of God, don't issue orders saying you can't use Gen AI. And if you're gonna, wait, Gen AI, okay, you can use Gen AI, but you need to disclose to me to use Gen AI. How many of you have ever signed something that your paralegal handed you? Or a young associate? Nobody in this room, I'm quite sure. So why do you need to tell me that you use Gen AI? You probably wrote that thing a little bit better if you used Gen AI because you cleaned it up for us. So I'm not a fan of these orders that every judges are issuing around the country either.
Understood. Sadie, what about with law firms? I mean, what do you think? Are there AI ethical guidelines that solos or even bigger firms such as yours should be using and instituting in order to prevent some of these, MATA-like problems that we haven't just seen, but we continue to see years and years later?
Yeah, I think the firm has various policies that deal with ethics and transparency and communication and meeting your professional duties, right? The key here is really gaining an understanding of what that means in practicality, what the judge was referring to. And, that means things like understanding that not everyone is on the same playing field right now. So for example, I have a piece of litigation where I am going to be using the deposition verbit tool that you'll see a little bit later on, and opposing counsel has no idea what that means. Never heard of it, right? But I disclosed that I'm going to be doing that. That's in the case management plan. It's not something to pull on opposing counsel at the last minute. And so to the extent that those who have and are implementing can help with being transparent and communicating and disclosing what we are doing with our adversaries, I think all the better, because it's not a game of gotcha. This is the law. This is sacred. There's a different feeling when you walk in federal court. There just always has been, and hopefully always will be. But we have responsibilities that go beyond, in my mind, just the client. We have an obligation of candor with not just the tribunal, but with one another.
And Rebecca, to that point, obviously AI has affected so much. We've got penalties in courts. We've got, I'm a new lawyer. I come out and I've got maybe these ethics guidelines that I've got to adhere to in my state and now my law firm that I'm working at. How or is the education of these young lawyers with AI being impacted from that professional conduct or that penalty standpoint? Is that being addressed, and if so, how are you seeing it, Rebecca?
Well, definitely in the context of using AI ethically, that's a huge portion of the education that we provide around AI. It's a huge part of the programming we did this past year. It's going to be a huge part in future years. And I think, like we've talked a little bit about this hallucination problem and like judges putting things in orders. And Sadie kind of mentioned that attorneys are not on the same playing field. And what's interesting to me is that, so there's this website you can go on to, you could see there's this attorney in France who's collecting all of the hallucination cases worldwide, right? There's about 1,000 of them now. He just hit 1,000. And the vast majority of them, first of all, are self-represented litigants. And then of the attorneys, the vast majority are small firms and solo firms. So I think there's a real disconnect between the types of tools that people are using and their knowledge about those tools. So like part of what I really try, one of my main points every time I talk about AI to law students is that it's not the same as a search engine. And that seems like a pretty basic thing. Like I'm sure everyone in the room knows that. The law students don't know that until we're now getting students who've gone through their whole college career having access to generative AI right alongside Google, right within Google. They might not think of it as that different. So like that education of it's serving a different purpose. If you maybe want help cleaning up your grammar or figuring out how to reword something, yes, that's a great use for AI. If you want to find cases, don't use free ChatGPT. It's not going to give you real cases all the time. And so I think that's a portion of it. I think something that we're also concerned about is, we talk about penalties. We're also concerned about students using AI in their own work and like submitting things to us that have been produced by AI. That's a pretty hard problem to solve because there's like AI detectors out there. They're not perfect, and it's hard to give a student a really harsh punishment if you're relying solely upon this imperfect tool. So that's something that I think law schools are still working through. Maybe we can kind of like shift our assessments to be less tempting to use that sort of AI, or maybe we assess different things. So that's the thing I think that law schools are still working through. But the education around ethics and that's one of the first things law schools started teaching too. So I think it's crucial, and we're treating it that way.
So Rebecca, I'm going to stay with you then here for a minute. Are we seeing students that are a little bit more like those left laners that are just really excited and eager to go after this? Or are we a little more cautious right lane folk, a little more concerned as they see the presence of AI in their education?
I think I see the concerned students more, honestly. I don't know if other educators have the same experience, but I'm kind of surprised because I teach like a legal technology class, and every year students come in and there's a few of them that say I'm not really interested in using AI at all. I think it's unethical. I think I don't want it to replace my judgment. I'm gonna do it all on my own. So there are students like that, and then there are students on the other side who are super excited about it and want to learn all the new tech and want to, learn all the new ways that they can integrate it into their practice. But then there's, I think the large majority are kind of in the middle where they don't really know a lot about it. And it surprises me that they don't, because like I said, they've come through, they've used it for maybe their entire undergraduate education now, but they still have these really basic maybe misconceptions or just haven't used it. I think probably most students will say that they have used it at least for some classwork. But they're often very surprised at the capabilities that it has, particularly beyond the free. That's what they've had available to them. And so, so part of our work is kind of understanding what the newer capabilities are and how that differs from what they might have been exposed to.
Gotcha. Well, Sadie, in light of that, knowing that we have cautious students coming out, but students that have experience with AI, we've heard, and it's been around for a while, right? The lawyers are about to get replaced. And our keynote spoke a little bit about it. Thankfully, we don't have robots falling on the dog or the cat or the toddler, as he gave an example. But do you believe or do you see that AI, and I'm actually going to go through the whole panel on this singular question, is AI going to put lawyers out of work and judges, in your estimation?
I think the place where generative AI will put people out of work is if they choose to ignore it. There's a lot of fear around generative AI and what that means to me, particularly for individuals who are in practices that don't have the level of support like you've heard about my firm having. For those people, I would say, be proactive, leave here, go to your firm and say, I am now the AI team, and dig in. To the judge's point, you need scars, which means you need to start learning this stuff. And in learning it, believe it or not, none of us are experts. And we had this conversation last night. We are the same as you. We just have spent some time with the generative AI tools. That's all that separates us. That's it. What also separates is the level of resources that are supporting us in accessing the different tools. These are things we can fix, but I don't see any time in the future the generative AI displacing people unless we have people who don't understand generative AI just automatically doing the Mad Max in the left lane, or people deliberately staying away from it.
Judge?
Well, I don't know if I want to sit next to Sadie anymore since I'm a state court judge, and her awe of federal courts and not state courts. Look, is anybody satisfied with the speed of which you get your rulings back? I don't think I'll ever see a hand raised, and so I don't think that it's going to replace judges. At some point, again, we might sign a different social contract and it replaces judges, but at this point, I think it's going to do a good job augmenting what we do and enable us to actually get through the backlogs that most state court judges have, and enable, it might replace some of the support staff. Again, I would never replace my clerks with a Gen AI tool, but a lot of judges don't have clerks. They can't afford clerks. And so, we have central staff for criminal, but we don't have central staff for civil. And so, the costs are coming down where, if I had a budget and I had a true technologist, because trial courts and courts in general don't have technologists. We have people who keep the servers going and say, here's your laptop and call me when you can't start Zoom. That's what we have. We don't have true legal technologists. And so when we get to the point where we can, build on-prem Gen AI tools that do central staff work for us, which we could do today. If anybody has a couple $100,000 for me, I'll build one. But then we can do from the time of filing. So I always joke that you all are building F1 cars for a dirt track. And so if I can, give you at least a paved track with the push of buttons, you could push through our case management systems where we can do all the checking. We don't have to worry about everything. The citations are good or they're not good. We can do you exceeded the page limit. Here's a draft order saying deficiency, correction needed. There's a lot of things that we can do to go through it, and by the time it gets to me, I have a bench memo with a perfectly indexed record. Those are things that we can do today if we had true technologists inside. If I had Sadie's team and Sadie's budget, it's always about the budget for the courts. If I had Sadie's team and budget, then we could be to a point where we can handle the capacity that you all are sending us and get the work out in a much more timely fashion. And so I don't think that anytime soon these tools are going to replace judges. I do think at some point it will replace some of the support staff, but it's not even replacing because we don't have them. And so, then it's up to the legislature if they think there's too many judges or not.
Now, Rebecca, what about the students? I mean, are they concerned that they're going to be coming out? They're the junior person in the room. They pass the bar. They get a comma, 3 letters, and a period, and they're supposed to go up, against a lawyer like Sadie who's been doing this for a while. And so are they concerned that AI is effectively going to render them irrelevant?
Yeah, I think so. Yeah, I get the question from students all the time. And you even hear, I hear a lot of talk about, like, is the billable hour going to survive AI? Is the pyramid model going to survive AI? Are we instead going to move to like a column model? And you even heard our keynote speaker kind of allude to this, that maybe we'll move more towards an apprenticeship model where instead of, presiding over a team of 20 lawyers, you've got like a couple that you kind of have by your side. So I think students are concerned about it. I'm concerned about it like from a law school standpoint. My livelihood is education, and if there's fewer lawyers we need, there's fewer lawyers we need to educate. So I worry about it from that point of view. But I don't think we know, because there's also, people heard of Javon's paradox, which is the idea that like if the more that AI can do, kind of, the more work that opens up. So if some things can be automated, then that just enables more and more and more work. And so people wonder, is that going to happen with the law? Like maybe we have such an access to justice problem in this country, there's so much unmet need out there for legal work that maybe it means that we're now going to be able to serve so many more people. And I don't know what the answer is, but I do think that that both Judge and Sadie are right, that if you know how to work with these tools, you are much better positioned. And that if there is maybe going to be less work to go around, if someone can do a junior associate's job, instead of needing 5 of them, you need 1 of them, then the one person who knows how to use those AI tools and who knows how to fit them in their workflow and knows how to use them smartly is going to be the one that gets the job. And so that's what we're trying to equip our students for.
And can I jump in here, because Rebecca said a couple of wonderful things that I think is important to note or to highlight, and that is everyone in this room needs to be intentional about raising up the next generation. You can't just say, and it goes back to it's profit-driven and therefore I only need 1 associate versus that's absolutely true in this world. If you're a 15 or 20-year attorney who knows what they're doing, you absolutely don't need 3 associates. But when you're gone, who's going to tell the bot that it's wrong? And so if you're not intentional about raising up the next generation, there's nobody going to be there and say, that tool is just dead wrong and we need to fix it. And so, that's a challenge to everyone in this room, and I know that, that's, I guess, the whole point of this fellows program is, raising up the profession. So I challenge each of you all to be intentional about that going forward. And so that is really all we need to do is be mindful of these things, and we'll be okay.
I would agree, Judge. Thank you. So kind of that last topic that I had for us before eventually we'll get to a few questions. As technology is increasing, we're seeing it in deep fakes, we're seeing it in evidence. I had the privilege to attend a meeting even in my own office with a great colleague who was able to share some wonderful insights and gave a presentation about different images and can we spot differences in images and are we able to do it in the evidence that he was able to share with all of us is that on our best day as a human being, we're able to spot 50 to 60%. As just a reminder here for those who finished watching the World Baseball Classic, anybody who's a great batter at that level, around 300, 400, they fail 60 to 70% of the time. Here, human ability to judge this evidence of videos and images is this way. How is this affecting, I'll start, Judge, first with you, given those contexts and what you're seeing, how is deep fake evidence and evidentiary issues that are being generated with AI impacting the court?
Yeah, this is what keeps me up at night. I'm sure it keeps everyone up at night. As you saw with Mr. Kahn's video, the video is still kind of wonky. It's awesome compared to what it was only 6 months ago, but it's still a little wonky. You can kind of tell. Photographs, I'm not so sure you can tell anymore. When it comes to human beings, there's still something that you're like, what, that just doesn't feel right. But when you're looking at objects and wildlife, you can't tell. I have a whole real or fake slide deck. It's fun. And they have them online, so try it. Voice is what scares the heck out of me. I had dinner with one of your fellows last night who was a former DV prosecutor and now a judge, and I was a DV prosecutor and a trial court judge who signed protective orders all day, every day. So this is how this is going to go. My wife and I have been together for over 30 years. She knows everything about me. I know everything about her. She has my voice everywhere, and you all do too. And if you left me a message, Lisa, I own you, because I can clone your voice in 2 seconds. Anybody can walk into court and play this, and my wife will have a ChatGPT, draft a threatening phone script, walk into court, play it for the judge, and get a protective order every day, all day. I lose the cats, the dogs, the guns, everything. And everybody in there is probably a private lawyer going, metadata. And I'm like, do you understand what the trial court looks like? That's not how it works. Somebody walks into court and goes, Judge, I'd like to play that for you. And so my wife's going to go in there and play this phone and play this tape, and I'm going to jump up and say, objection, that's not me. And what's he going to say? That goes to the weighty evidence, not to the admissibility evidence. It's been authenticated by that woman has known you for over 30 years, admit it. And you're going to lose, and you're going to get the protective order, and everybody's like, well, I might win 2 years later because then I get the subpoena of the cell phone records, and then I can prove it all. But that's over. It's done. And so I always thought in this day and age that this whole notion of you may not knowingly offer false evidence wasn't good enough in the deepfake world. And that we should raise that standard to be something along the lines of you must use reasonable diligence before offering evidence, because the court can't handle this issue on its own. You all are officers of the court, and we need participation. And so what we did in the state of Louisiana, instead of going after the rules of evidence, which the federal rules of evidence they're looking into, they're still studying, they have a couple of things that they might come up with, a new 707 and modify 901 and all of these other issues. We took a different approach and went after it in the Code of Civil Procedure and essentially said a few things. One, this reasonable diligence notion that, look, ask a few questions of your client before you offer it, like, where'd you get those photographs? Where's the phone that you took those photographs? Did you save it in the cloud? At some point, your BS meter is going to raise, and you're going to go, all right, I'm not saying authenticate every piece of evidence, but use reasonable diligence. Also, if you're going to have any reasonable suspicion that your opponent is using synthetic evidence, deepfake's a nasty word. It could also be AI-enhanced evidence, which is intentionally being used. Raise it in pretrial so we can have a conversation. Yes, we'll live in a motion eliminate hell, but I'm not trying this case 2 or 3 times because you run around and yell deepfake in front of the jury and then it's over. You know, we're not doing that. And so even if you don't have those laws in place, I tell every trial court judge, put it in your pretrial conference order. Make them do it ahead of the game so that you can address it ahead of the game. And so that's really the big concern with all these. And if you don't think it's going to happen, it's already happened. I'm sure y'all have seen the Alameda County case where the pro se litigant attempted to file a motion for summary judgment and put in deepfake evidence. It was so bad, the judge was like, I can see it. This isn't going to happen. But you saw the Ring video that Mr. Kahn had. That's what she did. She took a little Ring video and put a security officer into it. Deep faked some witness testimony, all these things. But you can tell today, and I shared this at dinner in 2024 when ChatGPT 4 was around. Sam Altman said ChatGPT kind of sucks today. And I want you to frame that. So if ChatGPT 5.4 kind of sucks today, what does tomorrow look like? And if I can't tell anymore today, and Will Smith can eat pasta perfectly now, where are we going to be in 6 months, in a year? And that's why I think it's going to be a team effort as we go forward with this deep fake stuff and ensure that everybody is playing, with the same deck of cards, because you can't tell anymore.
And to that point, Sadie, I mean, we think about people walking in our doors, right? We're meeting with clients. We're meeting with them virtually. And that's, since COVID, that's become the most advantageous way to broaden law firms' abilities to meet with clients. And now they're presenting this type of evidence. What is your firm seeing, and how are you addressing these concerns about synthesized evidence or deep fake or AI-used evidence that is coming in the door or virtually coming through?
Sure. So we anticipate that 2026 is going to be the year of the pro se plaintiff, and that the courts are going to be flooded. And in that vein, it's very easy to begin with those cases, but we do have it easy because we're an employment labor firm. We don't do domestic relations. There are no real emergencies in our world, right? So we have time on our side. Other people don't. And so while we don't have that urgency, we do have an ability to prioritize our resources. And so those resources focus in on when that wave is going to hit, and we've started to see the stream, and beginning to take a look at, okay, what's going on here? How can we wrap ourselves around it at the beginning using, litigation hold and all that stuff to our advantage as best we can to set ourselves up to be able to have the conversation more efficiently with the tribunal later on. I've got nothing for the people who are doing DR. I mean, that is, I love the judges' insights on that. I think they're right on. There has to be some level of raising the bar on the evidence that is presented to a court for submission. Unless you've done that forensic dive, and in my world, you're doing more of a dive than not, unless you're doing that, we've got a real problem.
Understood.
And so it is our duty to jump in as well.
I would agree. Ladies and gentlemen, we've reached that point now where we're going to be able to take a few questions. And so I know Judge has the microphone. So if you're able to just raise your hand, microphone will come right to you.
Thank you. Thank you very much for your presentation. I know Sarah Moore mentioned that your firm has developed some policies that are giving guidance to the persons in your firm on use of AI and how you're employing it. And I was wondering, for persons here who are looking at perhaps developing those policies, I'm familiar with the ethics guidance and ABA opinion 512. I didn't know if there were some other resources that you could share with everyone here as they're looking to perhaps try to develop some of those policies for their own firms and their own use. Thank you.
Sure. So what I'd suggest is if you have questions around policies, please come in and talk to me afterwards, because there are some resources that can be helpful. Our policy is 2.5 pages long. It's not a long policy. It just says how we use it, what's allowed, what's not allowed, that you can't upload the not allowed things onto our platforms or onto our cell phones that have access to our system, and references or other information policies and confidentiality policies. So it's a very hyper-focused policy, and I hope that's helpful to you.
We've had some recent issues, or at least I have, where my clients will throw our conversations into ChatGPT. And I'm just wondering how you've dealt with some privilege issues and confidentiality issues, and any suggestions on that, because once it's out there, and our clients don't quite understand that. They're kind of trying to fact check us, and then it's the cat's out of the bag kind of thing.
It's all about having the conversation up front. Can't stress enough how important it is to have within the initial intake the conversation with the client about generative AI. Just the basics. This is good generative AI in law. This is bad generative AI in law. Do not do this. If you do this, you could lose the privilege with me. That's a big no-no. And the more you do proactively with the client, the better.
Yeah, and that's a great point. So everyone that has the protective orders that tell your opponent you can't take my client files and put them in Gen AI tools, tell your clients the same thing, because you're handing, the protective order, you're handing your clients the information, and then they're going behind your back and putting it in as well. So make sure that your protective order includes not only the lawyers, but the lawyers' clients.
Hi, I was curious if you know whether or not any of the licensing bodies have considered making a CLE requirement, as an add-on, in addition to professional responsibility, a technology requirement going forward so that it can raise the bar of competence?
Yeah, so a couple of states do have a tech CLE 1 hour requirement. I used to, again, I don't like rules for rules' sake. I don't like these orders and all. And I used to think the hallucination problem would go away, and it hasn't. So I'm now on the bandwagon of we should require 1 hour tech CLE for everyone with real AI training, not just, jazz hands AI training, but, actual, here's what it does, here's what it doesn't do. And it's not going to fix the problem, but hopefully it reduces the problem. So I agree with you, we need to start doing that. And 1.1, Model Rule 1.1, Comment 8 says you should be tech competent already.
Yeah, I agree with that too, and I do think it's interesting that some of the sanctions for these attorneys that have run into hallucinations do include that CLE training. So if you're going to do that, why not require it of everyone?
I will say I have given a few CLEs on this to law firms, and certain law firms I've spoken with, they are requiring it. So not necessarily per se an entirety of the bar problem, although it is, that should be addressed. Some firms are requiring this annually within their own firms.
I'll also share a number of the bar associations throughout the state are getting together and putting on CLEs relative to IT, and that's been very helpful to move the needle as well.
All right, anyone else? All right, with that then, I would say thank you to our esteemed panel. We really appreciate it today. Thank you, ladies and gentlemen.
Great discussion. Thank you very much again to Jay for curating such an interesting exchange and opportunity to really explore conversations of AI all the way from the law school to the firm to the bench. I think pretty thought-provoking, some good fodder for our lunch discussion. Quick reminder at the end of the afternoon to turn in your CLE forms to the registration before you head out. At this point, we are going to get an opportunity to break for lunch. To keep it simple, we made 2 lines. So if you're in this half of the room, there's a lunch for you behind you, and there's a line for this half of the room right back there. We've got some high tops in the back, so you can mingle and get a chance to catch up with some friends over lunch. And then we will resume the conversation again at 1:15. Thank you.